Hi everyone, welcome to 01. I'm Jamie Austin. I'm the curator and director of programs here at 01. And if you're not familiar with us, we're an arts nonprofit where art meets technology to shape the future. And we opened up this space in downtown San Jose a little over a year ago. And our fall exhibition, which hopefully if you haven't had time to explore already, you can take a peek at the end, is Patent Pending. And it really explores the relationship between artists, invention, and ownership. And really part of the goal of the exhibition was to kind of investigate the role of patents in the artist community. Patents are something they've made the headlines a lot lately. There's terms like swords and weapons that have been used, tied to patents, but really they're also kind of a document in a piece of paper, but also kind of tied to this history of invention in the United States. And so really part of the goal of the exhibition was to be able to look at the system a little bit more deeply, to ask questions, to poke at some of these kind of sticky issues tied to that. And that was really the whole motivation for the event tonight. So the event tonight looks at the motion, the US patent system stifles innovation. And I'll let our moderator introduce all of our panelists that we have here in the back. But this is an Oxford-style debate. That means that audience participation is something that's encouraged and actually is incredibly key. Just a few kind of quick guidelines, and then I'm sure Eric will say more. But you get to determine the winner of this event tonight. So we'll be taking a vote at the beginning by a raise of hands and counting those. And then our panelists will debate. There'll be a time for audience questions, so please speak up. We do have a question area that's on this side of the stage with a microphone, so I would ask if you don't mind introducing yourself briefly, at least your name, and then ask your question. And you can be part of the debate. And then at the end, we'll be taking another poll by a show of hands, and whichever team has swayed the greatest number of people will be declared the winner of our debate event tonight. So this all comes down to each of you in the audience. So thank you for being here and participating with us tonight. I would like to introduce Eric Goldman, who's our moderator for tonight. Eric is a professor of law at Santa Clara University School of Law, where he's also the director of the school's High-Tech Law Institute. His research and teaching focuses on internet law, intellectual property, and marketing law. And before becoming a full-time professor, he practiced law in Silicon Valley for 8 years. First at Cooley Godward LLP, and then as general counsel of ePinions.com. So he has a really interesting background, very much tied to Silicon Valley and intellectual property that I think will really contribute a lot to kind of moderating the flow of this debate with the other panelists and participants. So the debate will last around an hour and 15 minutes. We're going to be very strict with our times. And then afterward, we'll have a little bit of time if you want to explore the exhibition more, talk with all the debate participants, and kind of continue the discussion beyond. So thank you for all being here. If you want to know about more of our events, if you do grab a brochure, we have one more event coming up on November 21st, which is tied to Catherine Richards' project, Method and Apparatus for Finding Love. And other events are listed on the brochure, and then you can sign up for our newsletter, 01.org, to get an email about everything going on here. So thank you, and with that, I'd like to pass things over to Eric.
Yeah, thank you, Jamie. Thank you, Jamie. And thank you to 01 and its sponsors for putting on an event like this tonight. Let me ask you a question. What is harder? Is it harder to get a patent or harder to get to this event on the 101 or 280? Tonight, I think that the patent's the easier thing to get. Tonight we're going to debate the question, does the US patent system stifle innovation? I know many of you think about this question from the perspective of what do we need to do to motivate people to make investments in innovation? I'd like to, just as a starting point, frame the debate a little bit differently. I'd like to think about how we structure our marketplaces and how patents fits into that. Ordinarily, we prefer free and competitive markets. It's just intrinsic in our culture that we favor free markets. There are some systematically dysfunctional aspects of free markets, so we generally have to put some regulation in there. But overall, we rely on competition to solve many of our social problems. And consistent with the favoritism towards free markets, we have a strong distrust of monopolies. When we see the marketplace controlled by a single actor, we get nervous about that. And the roots of that distrust of monopolization go back to the founding of our republic. The Boston Tea Party was a revolt against the monopoly of the East India Company and its control over the supply of tea. We have some exceptions for monopolies in our society. One example might be utilities, where the investments in the infrastructure might be wasteful if they were provided on a competitive basis. But patents are another similar exception to the baseline of competitive free markets. So as an incentive to spur innovation, the sales pitch is that some innovators can obtain exclusive control over the marketplace for the innovations that they create. And I'm going to use the term monopoly in this context, but it's actually not an affirmative right to enter a market. It's the right to keep other people from entering into a market. So in other words, what we do is the government rewards innovators with a patent. It's a payoff for making the right kinds of socially valuable investments. And in order then to do that, we make an exception to this baseline of free markets. If you think about it, you might think about a monopoly as a payoff for a certain type of activity as a bizarre type of solution, but it might make more sense if you think about it, especially in the context of free markets. What the patent monopoly does is encourage innovators to make socially valuable investments guided by where people would be willing to pay most for those outputs. In other words, once you get control over a marketplace, if the marketplace values that innovation highly, you will be lucratively rewarded. If the marketplace doesn't value that innovation at all, then there will be no rewards whatsoever. And so the idea is that the marketplace sends signals back to innovators through the mechanism of patents to tell them where they ought to make their innovative bets. And we might prefer that approach to some of the alternatives. We could, for example, imagine government doling out money on a fiat basis to the people it thinks will be most likely to produce innovation. That's a very anti-market approach, but in some ways, so are patents. What I'd like to do now is take a quick survey. As Jamie indicated, we're going to establish a baseline attitudes before we start making our sales pitch. And so you have three options: yes, no, or undecided. And if you're undecided now, that's perfectly fine. If you want to engage in some kind of strategic voting where you're going to change your behavior later just to reward one or another, that is an opportunity too. I hope you won't do that. The question that you're going to be answering is, does the U.S. patent system stifle innovation? So the first group will be the people who believe the U.S. patent system does stifle innovation. Raise your hands high and keep them high so that we can get a count. Remember, you are reaching for the gold that's up there in the sky. So grab high. Okay, the next group of people will be people who are voting no. That the U.S. patent system does not stifle innovation. If that's where you stand, raise your hand up, high enough that it can be counted. Wait, I see hands already going down. Put it back up high. Let's smell your armpits.
9.
Okay, and now the last group is the group of people who are undecided, who walked into this hoping to make a decision on this question. Raise them high. Okay, very good. To guide us through this discussion, we are lucky to have 4 excellent and different perspectives that are going to be introduced here. Let me just briefly introduce our debaters. Our first debater will be Christopher Kelty. He's a professor at UCLA and author of a book on free software. And he's going to argue in the pro position for the debate proposition. The second debater is going to be arguing against the debate proposition. His name is Jaz Banga. He's a serial entrepreneur. He's CEO and co-founder of Connected Patents and holder of 37 patents. The third debater will be on the pro side, and that'll be Laura Sydell. She's the digital culture correspondent for NPR. I trust many of you have heard her voice disembodied. Tonight we will hear her voice embodied, and what a treat that is. And among other claims to fame, Laura did a two-part series on patents that many of you may have heard that really exposed some of the practices of the patent troll. And our last debater is going to be Scott Snibbe. He's going to be arguing against the debate proposition. He's an interactive media artist, researcher, and entrepreneur. He's the holder of 15 patents, and he's the artist who designed the exhibit right over there. And with that, I'm going to turn it over to our first debater, Christopher.
Cool. All right.
5 minutes.
I guess I'm ready to go then. Is this on? Don't start it
Yes,
until
it should
I'm
be.
on. Okay. All right. There we go. Is it? Home.
I'm going to try and turn this off. There, I can figure it out. Okay, I think that worked.
Okay. All right. I was on the debate team in high school, but I was a really bad debater. But I did learn one thing, and that's to focus on the motion. So I wanted to start by asking what to stifle means. It means to kill by stopping respiration, to suffocate, to choke the life out of. A bit dramatic perhaps, but the question really is, what is the oxygen of innovation? What is it that keeps innovation alive from moment to moment, and what is it that can be stifled? So I submit that the oxygen of innovation is freedom. Freedom to operate, freedom to experiment, freedom from constraint and control, freedom to fail. So let me explain how the cost and complexity of the patent system interferes with and harms the freedom necessary to innovate. So the financial cost of the patent system is, to use a term of art, insane. Just getting one can cost anywhere from $10,000 to $50,000. Policing patents in our complex economy requires constant vigilance and large information and transaction costs. Licensing patents can cost enormous amounts. In domains like software, drug design, or engineering, where a single product might rely on dozens or even hundreds of patents, it can quickly become prohibitively expensive. And let's not even talk about the cost of litigating patents, which is positively spectacular. The cost is so high that a large number of people are driven to ignore patents, which is a cost or risk of a different kind. University researchers routinely make unlicensed use of patents, and this is bad both for researchers doing the violating and for the patent holders who risk losing their patents for want of asserting them. So the point is that insane costs create a real restraint on the freedom to innovate. But if costs weren't enough, consider complexity. The complexity involved is also truly daunting. Patents are written by lawyers, and lawyers, as you will learn in about 2.5 minutes, are smart. The result is that patents are downright impossible for anyone but other smart lawyers to understand. Patents are also, ironically, very easy to get. With millions of patents enforced in the world, it's no easy task to figure out what's patented, what's being enforced, or what you need to license. Many contradictory patents exist for the same invention. And challenging patents is an obscure, complicated, and expensive art. All this wastes time and sucks up the oxygen of innovation. To the point, insane complexity is also a real restraint on the freedom to innovate. So if innovation needs oxygen, an environment rich in freedom, does the patent system provide it? No. What the patent system does is put innovation inside giant iron lungs. You know those big machines that keep your lungs working when your diaphragm muscles fail, right? Or you can think of Darth Vader's costume if you need to have an image in your mind. These iron lungs have names like IBM and Microsoft, Pfizer and Novartis, the University of California and Stanford University, and lately, Intellectual Ventures or Rockstar. All of them hooked up to a single oxygen tank containing not freedom, but an apparently infinite supply of smart lawyers and money. So, inside these iron lungs, lawyers battle cost and complexity to create just enough space for tiny amounts of freedom. And the result is that innovation? No. It's the mighty global potlatch that we know as Apple versus Samsung, right? In which the ownership, for instance, of a single swipe of an index finger hangs in the balance. But, I'm here to tell you, another world exists. Outside these iron lungs, there's a green world, rich in freedom, competition, creativity, and therefore innovation. It's not a winner-take-all world, like the one inside the iron lungs, but one with lots of winners and nearly as many losers. Not nearly as many losers. For about 30 years now, for instance, free and open source software has gone on without needing the patent system, innovating not only the technologies we use, but the processes by which we create and distribute them as well. Inspired by free software, modders of all kind are innovating, sharing, remaking, remixing everything from game consoles to smartphones to hot rods and backyard fusion reactors. True. Restaurants and chefs innovate constantly and steal each other's ideas. Fashion designers innovate designs twice a year in the industry, and the industry is booming. Comedians and magicians are in constant competition to come up with new tricks and new shticks, all of them without any intellectual property protection at all. The innovation happens because the environment is rich in freedom. No one has to license the parts of a joke. Imagine if you had to pay to say a guy walks into a bar or every time you had to tell a joke. No one has to search a database for recipes or figure out whether or not someone's created that recipe before. And in this green world of innovators, the debate is also about the balance between personal gain and public interest. And if a practice restricts freedom, that is cause for alarm. But if it's a good idea, it's respected, it's emulated, it's even copied, used and reused, because innovation, like breathing, has to just keep on happening. But this isn't happening in the iron lungs of the patent world. This is the part where I just start the So, I'll stop there, because I'm out of time.
Thank you, Christopher. Okay, our next debater is going to be Jaz Banga.
Hi, good evening. Good microphone here. Can you hear me okay? All right, it's nice and loud. All right, first, I would like to start with, I didn't want to start this way, but I wanted to say that I'm not an attorney, number one. You made several references to attorneys in this space. I'm a founder, I'm representing a founder and an inventor, and all the people that start companies and eventually benefit off of patents. So the topic is, does the US patent system stifles innovation? I think absolutely not. Absolutely not. So, and this is why. Innovation and patents are two completely different activities. So when you think about the television being invented or the telephone by Alexander Graham Bell, you look at all these great inventions, what happened is that the inventor goes to solve a problem first. And they go to try and find a solution for something that doesn't exist yet. So inventing happens first, and then you file a patent. So these are mutually exclusive. So I don't care what's going on with the patent system. I don't, as an inventor, I know some other inventors also that I've spoken to, we don't decide to solve a problem or not solve a problem based on the fact that there's patent law against it. So that's the first point I want to make, is that innovation and the art of doing patents itself is completely mutually exclusive. Number one. The next thing I wanted to cover on patents is, we hear everything, you've heard the term, if it bleeds, it leads. We hear about Samsung, we hear about all these other different issues in patent lawsuits and things that are going on. But the patent system, and you know this when you file a patent, and if you've ever had any kind of a contest with the patent office, the patent office and the legal system are completely separate. And so if you have some sort of a complaint about even the registration of a patent, you have to go through the legal system, and then the patent office does something. So again, the patent office is not the one that opens the loopholes for a lot of the patent trolls and a lot of the people that take advantage of patents. That's usually done by the trolls themselves. The other point I wanted to make about patents themselves is that the patents themselves are a really genius method for the government to be able to share innovation. So when you think about an example for you folks would be drugs. So you think about Tylenol or some of the medicines that you take. The patents are granted at the very beginning because there's a lot of research and development that goes into, and you invest a lot of your time and people's time to build a product, and you hope to recoup that investment. And so what happens though is you only get a limited window with that. It's about 20 years with a patent. So what happens after 20 years, it becomes public knowledge. Anybody can use it. So it's not a trade secret, it doesn't stay hidden. So patents are a great way of getting and sharing innovation. That's what we like about on the patent side. The other side of it too is that patents for founders mean a lot. Patents, at the end of the day, when you have a young startup and you're innovating and starting some new technology, and you're putting your blood, sweat, and tears into that company, patents are a great way to be able to document that you were the first guy doing this. And so patents are a great way to be able to get credit for what you're doing. I have many patents, but I've never sued anybody with them because there's two types of patent owners. There's the patent owners that are the inventors, so the people who want to solve problems, want to share, are very collaborative, and that's the nature of inventing. And then there are the other people who own patents, which are the non-practicing entities. You've heard of NPEs. They're also called patent trolls. Well, they give patents a bad name. These are the guys whose only motivation it is to try and make money off the patents. They're not there to share an idea or a concept. And so, so ending with that, I think the real problem in the patent world is really the patent trolls. The patent trolls are the ones that have only a motivation to make money, and they're the ones that hold a lot of people hostage, even other inventors, they hold them hostage. So I do not think the US patent system stifles innovation.
Thank you, Jaz. Our third speaker is going to be Laura Sydell on the pro side.
First, going back to the motion, which is the US patent system stifles innovation. I want to make it clear that I don't think patents necessarily stifle innovation, but that the current US patent system, as it exists now, is stifling innovation. A patent is a government-granted monopoly for 20 years. That's a big right. And as my opponent here just mentioned, there are these things called patent trolls. Last year, there were more than 5,000 patent lawsuits, and 61% of them were brought by companies that don't make anything against companies that actually make something. So that seems a little bit skewed. Now, some might say that's great because all those patents were granted rightfully to inventors, and those inventors are getting rewarded for their good work, so they'll go on and invent more. But let's look at one of the most high-speed areas where a lot of patents are being granted, and that's software. A poll was taken of software engineers that showed close to 80% don't believe in the US patent system and don't even think there should be software patents. Part of the problem is that our patent office is granting patents at record speeds. According to a Yale study, the patent office is granting 100 software patents a day. It took 12 years to grant the first 1 million patents in the US. Now it takes less than 6 years to get another 1 million patents. Now let's look at one of these patents, which I'm very familiar with, or somewhat familiar with, patent number 6080436. It's a bread refreshing method, also known as toast, and that was granted in the year 2000. Let's take another patent, patent number 5771354, which was granted back in 1998 in the early days of the internet to a guy named Chris Crawford. Now the patent says it's for an online backup system. The patent says this invention makes it possible to connect to an online service provider to do a bunch of stuff, software purchases, online rentals, data backups, information storage, a lot of stuff we now think of as cloud storage, right? The only problem is that when he requested that patent, according to one expert who I spoke with, David Martin, who runs a patent assessment company, he ran this patent and discovered that there were 5,303 patents that were almost exactly the same. Exactly the same. Here's one, patent number 6003044 for, quote, efficiently backing up files using multiple computer systems, or patent number 5933653 for, quote, mirroring data in a remote data storage system. If this sounds like gobbledygook to you, it sounds like gobbledygook to a lot of the software engineers who have, many of whom have told me they don't even understand the patents that were granted in their name. According to Martin, 30% of US patents are essentially for ideas that are not unique. Not only that, but this same patent that I mentioned, Chris Crawford's patent, I was told by another attorney who used to be a software engineer that in the 80s, people were doing similar things. Now, this is just one example. So Chris Crawford, this particular patent, I did some investigation, was sold to, you mentioned, a very large patent troll known as Intellectual Ventures. This company makes almost nothing. It has assembled 70,000 patents. 70,000 patents, which it essentially uses, knocks on your door if you're a company and says, don't you want to buy our licenses? And that way, if you want to make these things, you know, then you can. Or, you know, if somebody comes and sues you, we'll help you. Now, this to me does not sound like a patent system that is actually encouraging innovation. This one patent, Chris Crawford's patent, was used to sue 16 companies. 2 of them actually fought back and they won. The patent was invalidated because Chris Crawford lied on the patent application. This is a common story. I just want to end with this one anecdote. I met somebody who wanted to start a company. His name is Nick Desaulniers. He's a young would-be entrepreneur whose father died of a heart attack, and he developed a prototype in graduate school and dreamed of starting a business. But then he did a patent search, and Mr. Desaulniers told me he was horrified to discover vague patents that covered a system for remotely monitoring physiological signs. What the hell does that mean, he says. He said, there are so many ways of doing that, he wondered, but I guess the patent covers them all. So he decided not to start his company. Now, that is what I call stifling innovation.
Thank you, Laura. Okay, our last debater is going to be Scott Snibbe, the consultant.
So there's definitely something wrong with patents, but fortunately, it's not that patents stifle innovation, or else Jaz and I would be up to getting completely clobbered by Laura and Christopher tonight. Luckily, the point to be debated today isn't whether the patent system is broken or imperfect, but rather whether patents stifle innovation itself. If patents stifled innovation, we'd be seeing a decreased pace of innovation. So let's take a look at that proposition to see if it's true. The strongest argument that patents stifle innovation is the billions being spent by companies today to acquire patents, to battle each other. But these costs should be compared with the value created by the current patent system. Innovation is a massive driver of American economic growth and job creation. And a well-working patent system supporting strong patent protection lets innovations turn into products and services that make money for the inventors. According to a 2012 study by the Economics and Statistics Administration and the U.S. Patent and Trade Office, IP-intensive industries accounted for 40 million jobs, or 28% of all jobs in the U.S. economy in 2010. According to the same study, IP-intensive industries accounted for over $5 trillion in value added, or 35% of the entire U.S. gross domestic product in 2010. So a lack of IP protection or changes that might break the imperfect yet thriving U.S. patent system could cause the collapse of trillions of dollars of annual value and cause a true end to innovation as production flowed to lowest cost offshore manufacturers, profits from IP holders evaporated, and incentives to innovation dried up. This is the far greater risk that our patent system might be weakened. Comparing the $5 trillion of value created by proper patent protection, the cost of patent trolls, as measured by James Besson and Michael Moyer, costs the economy $29 billion a year in direct costs, 0.5% of the total annual value created by IP protection. Now, from a more colloquial perspective, does anyone notice innovation slowing down? We have mobile supercomputers in our pockets that satisfy our every wish, self-driving cars, drones, robot vacuum cleaners, just about every essential piece of everyday software available for free online. So if patents were stifling innovation, wouldn't we be seeing a slowdown in innovation? From your personal perspective, does it feel like innovation is proceeding too slowly? To put it another way, do you wish that your phone was made obsolete faster? What patents do is stifle copycat implementation. The vast majority of patent lawsuits are made by patent holders against those who are infringing on a patented invention and who refuse to pay a license fee. That's what patents are supposed to be for. There is, of course, one central problem here, and that's that patent holders need not actually make a product with the invention in order to sue others that do. And that's what most of us strenuously object to, and fixing this might dramatically fix our patent system. However, I want to emphasize that this has nothing to do with holding back innovation, which is the central argument today. We aren't talking about how we can fix all the problems in the patent system, but merely asking if patents stifle innovation. There are three main sources of innovation: corporate R&D, academic research labs, and startups. Is innovation being stifled in any of them? Corporate R&D is quite easy. If you look at Apple, for example, they spent $4.5 billion in their R&D budget in 2013, up from $3.4 billion. That's about 2% of net sales. Apple's overall revenue is $170 billion, with net income of $37 billion and $147 billion cash on hand. With numbers like these, spending $1 billion for its share of the Nortel patent portfolio, which they're using, as to attack Google and companies like that. It's not an undue burden. And have Apple not having that extra $1 billion doesn't really make much of a difference to their success. It would just go further into a dividend or bolstering reserves. Academic research is driven primarily by peer reputation. Academics are going to be innovating no matter what kind of patent system we have. And individual inventors, as Jaz was saying, are driven by basically an insane risk-taking drive that's completely oblivious to the factors around them, and often to the point that they'll borrow against their house in order to get their invention made. So any changes to the patent system are unlikely to change that sort of wild mentality. So, in general, inventors don't care. They're often oblivious or actively contrary to the IP landscape and risks. They just want to see their innovations made.
Okay, so we have some time now for this to be an interactive discussion. I have a bunch of questions. Our panelists may have questions for each other. But before we do that, why don't we start and see what's on your mind? So we have a microphone and chair over there. If anyone from the audience wants to take the privilege, go for it. Or if not, I'm probably going to pick up. All right, well, while everyone's concentrating on their thoughts, off you go. If you could introduce yourself, that'd be great.
My name is Eric Goldman, and I'm an inventor or co-inventor of 12 US patents in the medical device area. And I have a question just for the panel in general. I have my own personal experience with the patent system has stifled innovation for a certain segment of inventors, and that's the little guy, if you will. It seems to me that if you're a multi-billion-dollar company, you're shooting for the moon, and $1 billion is 1% of the money you have in your pocket. Sure, it's not a big deal, but it seems for small inventors, the disincentive of paying $10,000, $20,000 a pop to get a patent from the get-go is really too high a barrier. And personally, from my own experience, I would actively pursue my next business, which I am very entrepreneurial. I would actively pursue a business that did not need a patent and was probably less innovative, but quite possibly easier to start and more productive for me, being a real inventor.
Comments from the panelists? Who would like to go first?
I think that's part of the problem, and now the system is first to file, not first to invent. So that means that even if you were the first to come up and build a brilliant idea, our system will reward the person who filed first, which is going to be the person with more money, once again rewarding the big players. And I think the problem is the little guy, like I mentioned to yourself, with our current system. And again, I don't think the motion is arguing against patents. It says, does the US patent system stifle innovation? And I believe as it currently exists, it's harming people like you, it's harming people like the young man that I mentioned.
So it's true that it's one thing that can happen to a small company as it gets successful is that a major company could sue them for infringement. But in fact, that's a very rare event because giant companies keep their patents like nuclear arsenals, and they're used primarily as deterrents against other superpowers, or rarely in a kind of Dr. Strangelove type insanity as they, start the war and make their attack. So it's far more likely that companies find small companies that are potentially infringing on their patents and buy it as the company meaningfully expands their capabilities. Now, this is kind of personal because I know Brett, and it just so happens this just happened with one of our friends, right? A company came to them, they were making medical devices, and the company said, well, we could sue you, or we could buy you. And what did they do? They ended up buying the company. In fact, it's the same or less price for the larger company to buy the small company, and it drives innovation. And this becomes a gigantic incentive within the startup marketplace that companies even directly decide to make something that's infringing on a major competitor, but to show that they can do the product a little better than that big company. They've discovered something new in order to be acquired. So I'd argue that you're right in some small cases, but in the larger ecosystem, it's extremely beneficial for small companies to infringe on patents.
So, Scott, I'm sorry, your argument is that you should look for patents, infringe them, and then hope that the patent owner will buy you?
That's a bit of an extreme statement, but there are companies that do that. They see a tiny little area. The giant IP landscape is dominated by this company, and then they see a little area where they can innovate. But you can't innovate without infringing on some of those larger patents. But because of the current IP landscape, it's to the advantage of the larger company to buy the small company rather than to sue it. So the current system promotes an ecosystem where innovation is rewarded.
Go ahead.
Yeah, just to give you some advice on the patent part, you mentioned, hey, I don't want to spend $10,000 or $20,000. So in our experience, and we recently, one of our friends we had helped out with, we'd sold his company also to Yahoo for a significant amount of money. It turns out that provisional patents, the patent office understands that. But if you look back at the history of patents themselves, even Abraham Lincoln was an inventor. And so they made it for $200. You can file a provisional now, and it's patent pending. So I run into startups all the time that are literally, running out of garages and don't have a lot of budget. And $200 is something they can afford. So with a provisional patent, you can file. There's a lot of great templates you can find online for that. I usually tell founders, look, a provisional patent gives you a year. So file like 3 or 4 of them if you can afford to do that. It covers your invention and when you did it. You mentioned earlier about the whole first to file being a disadvantage. I actually think first to file is an advantage for founders, and I'll tell you why. So first to file is basically you saying, I was the first person to invent this product, right? And in the old system, it was, hey, you could have what they call prior art. You could have an old invention that kind of supersedes yours. With the new system, it's really who files first. So what I tell founders is, hey, as long as you file as close to the time that the innovation actually happened. So let's just say, just for fun, you've invented an anti-gravitational hoverboard or something in your garage, right? Kind of like Back to the Future. Well, as long as you file, as soon as you really do come up with that genuine invention, you're pretty much guaranteed that you're going to be first in line for that. So again, recap, do the cheap filing because it gives you a year. In a year, you pretty much know if a startup's going to succeed or not. And then spend the money.
Just a quick thing. It sounds to me like this is an argument against the little guy, right? If your only option is to file for patents so that you can become part of a much larger corporation and be assimilated into the Silicon Valley board, then this doesn't sound to me like an argument for small innovators.
But luckily our debate's not about small versus large, it's just about promoting innovation. And this system does massively promote innovation because it encourages thousands of people to start original small companies because of that reward.
Start them and then maybe their idea just dies inside a big company. It happens all the time. I mean, the idea is that you want to promote the next Google. And you want, not just Google, you want to see the next new company come up and disrupt Google. And so right now, these companies, they amass all these patents. It is the little guy. They are the ones who often are going to come up with the most innovative ideas.
Why don't we take our next question from the field, please.
This is Harry Saul. So it's a very tricky motion and hard to understand. So I thought about it, well, let's look at the opposite of the motion. And if we look at the opposite of the motion, the people who are for it should be against it. So the people who are against it should be for it. The opposite is the U.S. patent system encourages innovation. And the people on this side ought to be in favor of that statement. Now, Jaz already said that he doesn't innovate because of the patent system. He's driven to innovate. And my question is really to Scott. Are you in the same camp as Jaz? Do you need a patent system? Does the patent system encourage you to innovate in ways that you would not innovate if the patent system were banished tomorrow?
Yeah, absolutely it does, because it's so easy to copy things today. I mean, the world we would live in without patents would be one that massively discouraged innovation, because everything would flow to the lowest cost manufacturer. I mean, I produce apps, and I saw apps that we made copied in as little as 2 or 3 weeks by, like Ukrainian
copyright law
developers.
that protects that.
Exactly, but that's
not
the
patent law. So let's get back to
No, but it's extremely relevant because without any kind of protection, then anybody could copy anything as fast as they can, sell it for as low a price as possible, and it would massively stifle innovation. So it's important to have these kind of protections so that you have a chance to try your idea in the marketplace, especially if you want to do it better than other people, spend more time, develop more time and money and resources producing it, and then somehow reap the rewards. Without the patent system, there would just be tens of thousands of vultures waiting around the few innovators.
But isn't that competition? Which is
That
something
is-
we also value in our system.
Right.
We have lots of examples, as I said, of places where we don't have patent protection or copyright protection, and there's lots and lots of innovation. So I think the point is, I mean, we should, you win the debate from my perspective, because we should be asking whether or not any of us actually believe that the patent system encourages innovation. It sounds to me like nobody on this panel believes that right here. And so that's a different kind of question.
I actually disagree with that comment. I actually think the patent system does encourage innovation. I'll tell you why. When you know how something works, so it's great to look at patents to see, I don't know if when you're a kid, you break things open to see how they work, right? A patent tells you how something works. You're looking at a magnet, you're looking at an electronic door lock, and you can see how things work. And that's the beauty of patents. They were invented to share that information. You also mentioned copyright. So a lot of people don't know that patents are in the Constitution. Under the it's a copyright law. It says anybody who really invents anything new has a novel. The exact words I have, kind of a little quote here, to promote the progress of science and useful arts by securing for a limited time for the authors and inventors the exclusive right to using their discoveries. So it's part of the Constitution for that too. So I hope that kind of helps you answer that side of the question. But
Can I just add one other thing to that, which is patents are also supposed to be granted for really big breakthroughs, not just for little incremental steps. And we're getting to a point where the US patent system is rewarding little tiny incremental steps. And that starts to stifle innovation because you end up with trolls. When your company goes out of business, you sell your patents, and somebody who makes nothing uses these little incremental steps to go sue people.
So that was a great argument that Laura had about the triviality of many patents. But the problem is that this general principle you mentioned goes through all intellectual and creative endeavor, right? 99%, or actually 99.9% of all literature is derivative, bad, etc. It's always just a tiny, tiny bit at the top of any intellectual endeavor that's strong. So I'm not sure that point is relevant to patents being valuable. And even
Patents
if
and
99%,
copyrights are not the same thing.
right, but we're talking
It's a
about
20-year monopoly that you get. A copyright is on a creative work like a novel, and so somebody can't just go and create and, word for word copy your novel. It's different.
intellectual property is. Yeah, intellectual property is intellectual property. So a copyright, whether you write a book, whether you write a great, if you wrote Breaking Bad, right? That's a product. That's a DVD. That's that's a storyline. And whether you created, I don't know, the Breaking Bad costume or something, that's an object. So the intellectual property comes in many forms, and that's actually one of the greatest, I think, one of the greatest assets of the United States. When you look at making things, like as far as production, yeah, sure, other countries can build things cheaper, make it in China and all that kind of stuff. But when it comes to creativity and inventing, this is something, as I was going through this at night writing notes, I was like, inventing is really like apple pie for America. Like you ask your grandmother about a patent and inventing, she'll tell you, oh, I got this great invention for, hanging a hat or something like that. And so I think it's part of the American, culture too.
I just want to mention about the Constitution piece, because I just want to clarify that. The Constitution does reference both copyrights and patents, but it gives Congress an authorization to enact the laws. It's not a requirement that they do so. And in fact, the founders expressed some severe skepticism about monopolies. Remember, our country was founded in a revolution in part because we were anti-monopoly. Let's take the next question from the field.
Good evening. My name is Beth Ferguson, and I'm a designer and professor and work with students around innovation and design. And one of my main interests is global climate change. And for innovators to be able to tackle that issue, we can't wait 20 years for an innovation to be shelved by a company that takes that idea, pays out $1 million, in how do we teach innovators, startups, designers, and students coming up with these ideas to be able to think really big, urban prototype these concepts, to not just make blueprint sketches and then put them on a shelf and never think about them again, but actually build them and not be afraid to have them be tested out, to get feedback, to have second iterations, be part of the innovation process, and take it a step forward to be able to solve some big global problems across the board that we know what they are.
Yes.
No, I mean,
Really
that's, I hope, you know, they're not violating anybody's patent, because they could then find themselves, you know, like. They could then find themselves being sued. I mean, this is actually, you know, potentially one of the problems that students can run into. They can actually step on some vague patent that they didn't even know about. They should be encouraged to think big.
And I just want to add that I think part of what's at stake in innovation is, as Jaz mentioned, is recognition for innovation, right? Not just that you solve the problem or that the problem is solved in some abstract sense, but that there is recognition for it. And that's one of the problems with the fact that we can alienate and sell these patents and move them around and people are afraid of being sued for them, is that people who are involved in the innovation process don't necessarily end up feeling like they own the problem and can attack it from their own perspective, and instead are afraid of their ideas having to be either patented or stolen from them, and so have to be defensively patented, and so on and so forth.
The thing is, far more ideas die for lack of resources than because someone has tried to sue them or buy them out of existence, right? And without someone investing in a major idea, particularly one that could have a global impact like climate change, the idea will die. And investors don't invest in something unless there's a way to eventually make a profit off it. And you can only make a profit off of something if you are able to get some IP protection for the billion-dollar investment you make for, you know, air scrubbers or so on, that you might eventually be able to make, you know, $1.1 billion a year and over $1 billion of expenses and some profit. So far more frequent that ideas die for lack of resources than because someone has sued them at some tiny moment. There's no reason for anyone to attack ideas when they're small.
Next question.
Hi, my name's Simon Linder. I'm a patent agent and I'm a freelance intellectual property correspondent. So I've been covering the Apple Samsung trial that's been happening a few blocks away. They just had a hearing today where they were going over evidentiary concerns, and Judge Koh near the end says, "Are you sure you want to do this?" Mentioning how 2.5 years ago she asked if they could just all get along. I have been surprised, however, the amount of information big companies like Apple and Samsung were willing to disclose just because of the patent system. Because when they had the jury trial, Apple at least brought out their top executives talking about the reasoning behind their marketing systems and their design process, and I don't think that would have come out unless when they were trying to use their patents offensively to try and stop the Samsung product from coming to market. But that's not what my question is about. The topic of IBM came up, and recently IBM has threatened to sue Twitter, which is preparing for their initial public offering, and they disclosed a few patents in which they're considering suing Twitter over. A while ago, Yahoo did something similar to Facebook, but it got settled when the new interim CEO decided to dismiss the charges and then left. So my question is what effects what effects does the patent system have on these bigger investments that have to deal with the companies that are bigger than just these smaller guys you're talking about, but still have to deal with the perspective of larger companies coming in and demanding things and trying to disrupt these new avenues of investment.
All right, thank you. We have about 2 minutes for this answers to this question. Let's start here.
Yeah, so I think it's important to bring this back to the central question, which is does the US patent system stifle innovation? So look at the Samsung versus Apple case. What happened, even as that case was moving forward, was that after Apple sued Samsung, Samsung was forced to massively innovate, and they completely abandoned so many of the things they were directly copying from Apple, and they created wild innovations, phones that sense your face when you're looking at them, all these incredible innovations. And then it forced Apple to further innovate because their phones started looking poor. So again, we have to be careful not to frame this as, is there something wrong with the patent system? But rather, the question we're here to defend, does the US patent system stifle innovation? In this case, I think it's very clearly answered that it only encouraged innovation.
I mean, I just have to say, I'm not sure what big innovations you're talking about. Samsung basically had to change the way people swiped the phone Samsung had to like change the way people swiped the phone. You know, there were no huge innovations. There were these like little modest innovations. And one of Apple's patents was basically a rectangle. You know, Apple patented a rectangle. And I'm not saying that Apple isn't a super innovative company. I just think there was a lot of personal stuff involved going on. Steve Jobs' last words, you know, he was upset at how much these phones resembled his, but they were also different, and actually a lot of what Apple patented was very, very generic. And indeed, Samsung and Motorola and other companies had made similar things. The brilliance of Apple is its ability to assemble lots of different things and sort of make them work better.
We're actually out of time for our questions. We're going to move now to rebuttals. We're going to start our rebuttals in reverse order from the initial speeches. So I believe the floor is yours, Scott.
Okay. So it may be worth just finishing off that last point, because Laura's correct. What Samsung did at first was they just changed the way you swipe and so on. But then what they did was they created an entire innovation laboratory. They started hiring like crazy and made some acquisitions. And the types of innovations, there are radical, wild innovations they've made, such as now when you look at a Samsung phone, it knows when you're looking at it and automatically turns on. And they have the patent on that, so now Apple has the fingerprint, and you get this quick innovation war rather than intellectual property war. So I want to go back to the corporate R&D. So corporate research and development, it's the engine of big company innovation, and that's what this lawsuit forced Samsung into, is to reinvest in innovation. So claiming that money spent on needless patent acquisitions and battles could otherwise be spent on corporate R&D is really a mistake. Corporate R&D is a small fraction of these companies' budgets. These kind of patent lawsuits encourage companies to spend more on innovation and encourage companies to make acquisitions of other smaller, more innovative companies. The point I was trying to make about Laura's point about many patents being poor quality isn't an argument against the patent system, of course, because patents are weak doesn't mean they should be banned. The majority of many of intellectual endeavors is weak, but the strong patents it become valuable.
All right, thank you. Laura?
Well, the motion, I don't know why.
You like this?
We're being sabotaged.
We're being sabotaged. The motion is the U.S. patent system stifles innovation, and I believe as it currently exists, it is stifling innovation. Right now, there are so many companies taking these really silly little patents and going out and suing people. A group called Innovatia has been going around suing coffee shops and grocery stores for violating its patent on providing Wi-Fi in a public space. They say they own that idea. Another company called Bowden Technologies LLC has sued a bunch of media organizations saying that one of its patents is infringed every time a word or phrase on your computer auto-completes. Something is rotten in Belgium. Now, when we're talking about the amount of money being spent on these lawsuits, we are talking about billions of dollars. In 2012, a jury awarded the largest patent verdict ever, over $1 billion to Apple. That's money that could have gone, that's money that could have gone, yeah, I guess so. That's money that could have gone into innovation, but instead it went into lawsuits. I think the only people who are innovating right now are lawyers. So the US patent system is stifling innovation. Thank you.
Thank you. Jaz?
Our mic's live? There we go. So I mentioned to folks earlier that the press goes by the old, if it bleeds, it leads. I think if you take a look at the position that the team over there is taking, every comment is about, oh, well, you know, this company was stopped from doing this, and Apple sued Samsung, blah, 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 back and forth. The question you gotta ask yourself from the patent system is, do patents do more good than they do harm? So, of course, there are lawsuits. It's a cost of doing business. When one of my professors, Dr. Freeman from the Haas School of Business, he told me, look, you're going to get sued someday for something. Whether it's somebody tripping on a sidewalk in front of your business or something, it's almost a cost of doing business, these suits. But in general, patents are good. If you just look at the amount of revenue that's generated from them, the amount, many people in this room, their jobs come from intellectual property, and that's intellectual property, whether that's a movie, whether that's a digital lock, whether it's an iPhone. So I think at the end of the day, when I mentioned credit for an innovation, I mentioned like when you work with enough engineers, you understand that they're not driven by the money. They're not driven by litigation. They're driven by, I want to be the guy doing the cool thing, solving a really hard problem. And I think patents are this way of documenting all those innovations. And so we see companies day after day, founders that have toiled, and I got to tell you, the guys who have put the time in to think about their IP and file patents, they end up getting investment, they end up having more jobs, expanding as a company, and I think that's, at the end of the day, it's a good thing for founders.
Thank you. And last debate point?
So, okay. We really are being sabotaged. No, I want to just return to my original point, which is about how the patent system stifles innovation by making it costly and complex to do innovations, especially as a small innovator. So the main points that we've been discussing about the patent system have to do with very large corporations amassing large numbers of patents and doing innovations at a very piecemeal incremental way. But there's lots and lots of innovation going out on in the world that isn't necessarily benefiting from the patent system. And I think the other team wants to have it, our team colleagues at the other end of the bench, want to have it both ways. They want to be able to say that the patent system doesn't necessarily cause innovation, but they want to say that it also doesn't stifle innovation. But you kind of have to choose. Why have a patent system at all if you can't choose whether or not it either promotes innovation in some form or stifles it? And true, you might not actually need a patent system you might not actually want the patent system to promote all forms of innovation, and it doesn't stifle all forms of innovation either, but it does more harm than good by stifling more of the innovation that's happening in the world today than it does innovation than innovation, other kinds of innovations. Good. I'll stop there.
All right, I'm going to say a few more words, but before we do that, I would like to give my appreciation to the debaters for such a great job of listening to their points and framing the debate. When I teach the patent module in the IP survey class I teach, I make a reference back to the Laffer curve. Some of you remember the Laffer curve from the 1980s, and it was the foundation of Reaganomics. And the Laffer curve said, we know two endpoints of the tax revenue system. We know that if we charge a 0% tax, we will generate zero tax revenues, because any number times zero is zero. We know that if we charge 100% tax, that we would also generate zero revenues. If you charge 100% tax, why would anyone work? They're just giving all their money to the government. And so Laffer posited that there will be some kind of parabolic curve where there will be a maximum point for maximizing tax revenue. And the argument, the foundation of Reaganomics, is that the current tax rate was to the right of that maximum. So all we need to do was reduce the tax rate to the left, and we would be scooting up the overall tax revenue that we would get because we'd be working on the backside of that parabola. And patent policy is not dissimilar. We might posit two endpoints. If we had zero patent system, we would get zero innovation. Now that's an overstatement, and please don't jump on me on that. And we might say another thing, that if we create too many patent rights, we might stifle innovation so greatly, no one would ever innovate because they'd be stepping on someone's toes, it would never be worth pursuing in the first place. And so if we take the analogy to the Laffer curve, or that parabola, we might have a similar type of parabola with the patent system. There might be an optimal level of calibration that produces the maximum amount of social wealth. And the question for us is, are we on the left side of that maximum, or are we on the right side of that maximum? It is time to vote. Now, in this case, just like on American Idol, we're sending some people home based on your vote. Okay, so we are ready to put the question to all of you. We are going to ask the question once again, does the U.S. patent system stifle innovation? If you agree with that proposition, please raise your hands high. Okay, we are going to ask the second question. I'm sorry, I should have been clear. We will still have the undecided category. It's okay still to be as confused or more than you started. That's what most of my students feel after my class. So the con to this proposal, that the U.S. patent system does not stifle innovation. Raise your hand high. Okay, and the remaining undecided. Can we reveal the results of the vote? Going home now.
All right, so I just wanted to make sure I wasn't incorrect. So it looks like the debate goes to the against the motion team. They started with 9 no's originally and ended with 14, so we're able to sway 5 additional people. The yes votes on the for the motion side swayed 1 person. They went from 6 to 7, and the undecideds went from 8 to 4. So with swaying 5 people, the debate goes to against the motion. With that, I think let's thank everyone, including Eric, our moderator, for all of the time and energy they put into the event. I also think we should applaud the audience and everyone out there for your participation in the event as well. And thank you so much for joining us for our Oxford-style debate tonight.